Welcome to EUPrivacyForAll Session45 on GDPR, Article 55 and 56, Competence of the Supervisory Authority. Articles 51 and 51A on the competence and competence of the lead supervisory authority were finally renumbered Article 55 and 56. In Article 55, on the competence of the supervisory authority, it is laid down that each supervisory authority shall be competent for the performance of the tasks assigned and the exercise of the powers conferred on it in accordance with the GDPR on the territory of its own member state. Where processing is carried out by public authorities or private bodies acting on the basis of legal obligation or public interest, the supervisory authority of the member state concerned shall be competent. Supervisory authorities shall not be competent to supervise processing operations of courts acting in their judicial capacity. Article 56 on the competence of the lead supervisory authorities lays down that the supervisory authority of the main establishment or of the single establishment of the controller or processor shall be competent to act as lead supervisory authority for the cross-border processing carried out by that controller or processor. By derogation, each supervisory authority shall be competent to handle a complaint lodged with it or a possible infringement of the GDPR if the subject matter relates only to an establishment in its member state or substantially affects data subjects only in its member state. In the cases referred to, the supervisory authority shall inform the lead supervisory authority without delay, and within a period of 3 weeks after being informed, the lead supervisory authority shall decide whether or not it will handle the case. Where the lead decides to handle the case, the supervisory authority which informed the lead may submit to the lead a draft for decision. The lead will finally take the utmost account of such a draft. Where the lead decides not to handle the case, the supervisory authority which informs the lead shall handle the case. The lead supervisory authority shall be the sole interlocutor of the controller or processor for cross-border processing carried out by that controller or processor. The key recital dealing with the notion of main establishment and the identification of the lead supervisory authority is recital 36. It lays down that regarding the controller, the main establishment will be the place of its central administration in the Union unless the decisions on the purposes and means of processing of personal data are taken in another establishment in EU, in which case this other establishment should be considered as the main establishment. The objective criteria to be used should imply the effective and real exercise of management activities determining the main decisions as to the purposes and means of processing through stable arrangements. That criterion should not depend on whether the processing of personal data is carried out at that location. The presence and use of technical means and technologies for processing will not be a determining criterion. Relating to the processes, the main establishment will be the place of its central administration, and, if it has no central administration in the Union, the place where the main processing activities take place in EU. In cases involving both the controller and the processor, the competent lead supervisory authority will remain the one of the member state where the controller has its main establishment, but the supervisory authority of the processor should be considered as a supervisory authority concerned and participate in the cooperation procedure. In any case, the supervisory authorities of those member states should not be considered to be supervisory authorities concerned where the draft decision concerns only the controller. Finally, where the processing is carried out by a group of undertakings, the main establishment of the controlling undertaking should be considered as a main establishment of the group of undertakings, except where the purposes and means of processing are determined by another undertaking. In Recital 124, the context of the activities of an establishment of a controller or a processor in the Union is referred to, and the supervisory authority for the main establishment of the controller or the processor is to act as the lead authority. It is also stressed that the board should be able to issue guidelines, in particular on the criteria to be taken into account in order to ascertain whether the processing in question substantially affects data subjects in more than one member state, and on what constitutes a relevant and reasoned objection. Article 416 defines main establishment. As regards to controllers, it is the place of its central administration in the Union, unless decisions on the purposes and means of the processing of personal data are taken in another establishment, and the latter establishment has the power to have such decisions implemented. As regards a processor, the place of its central administration in the Union would be the main establishment, or if the processor has no central administration in EU, the establishment where the main processing activities take place. The Directive 95/46 sets forth that supervisory authorities shall act with complete independence. In the paragraph 4 of such an article, it is made clear that each supervisory authority shall hear claims, and in paragraph 6 that each supervisory authority is competent, whatever the national law applicable to the processing in question, to exercise on the territory of its own member state the powers conferred by the directive, and each authority may be requested to exercise its powers by an authority of another member state. They've got also an obligation to cooperate. What should accountable data controllers and processors get prepared for? They will have to identify their main establishment in EU in order to identify their lead supervisory authority. The main establishment of a controller is, as a rule, the place of its central administration. As an exception, the establishment taking decisions on the purposes and means of the processing if it has the power to implement it. A caveat here, this qualification does not depend on the location of the processing or technical means. The main establishment of a processor is, as a rule, the place of its central administration. Exceptionally, if the processor has no central administration in EU, the establishment where the main processing activities are. Where both controller and processor are involved, the main establishment of the controller defines the lead supervisory authority. The one of the processor is a concerned supervisory authority, and it is part of the cooperation procedure. So the first derogation regarding competence is in case of infringement or of complaint related only to an establishment in one member state, or substantially affecting the data subjects of only one member state, entailing that the supervisory authority of this member state is the only one competent. There are 3 weeks for the lead to decide to handle the case or not. The second derogation regards the processing held on the basis of legal obligation or public interest. It entails that the supervisory authority of the member state defining it is competent. The third derogation comes from the fact that the lead supervisory authority is the sole interlocutor of the controller or processor for its cross-border processing. A consistent application of the lead and concerned supervisory authorities theory is a key question. Will EDPB provide adequate guidance and specify the way each controller or processor should identify the lead?